Hello friends, in the series on the income tax cases, today we will discuss a very important and a little bit different issue which is not very common. In the present case, there was a question of levying the penalty on the assessee for late filing of return, which is mentioned in section 285BA, and that return is for furnishing the information relating to the financial transactions, that is commonly known as annual information return. The question before the Kerala High Court was that if the assessee delays in filing that return and just take the plea that this return is delayed because the current officer was under the impression that this return has already been filed by the earlier officer, so whether this can be a reasonable cause for avoiding the penalty under section 273B. This issue has been taken up by the court in the case of Registrar versus Director of Income Tax Intelligence and another, and this case is reported in 483 ITR at page number 21. In the present case, the Sub-Registrar assumed his position on 12th July 2011, and in the present case, since the financial year was 10-11, so the due date of filing the annual information return was 31st August 2011. The annual information return was not filed. The assessee was issued show cause notice for the penalty, and in that penalty reply it was mentioned that the officer was under the belief that this return has been filed, but the officer levied the penalty and there was a delay of 525 days in filing this return, because ultimately the return was filed on 6th February 2013, which was much ahead with the due date of filing the return. When this penalty order was passed, in that penalty order it was mentioned that this order is appealable before the tribunal. So the appeal was filed before the tribunal. The tribunal dismissed the appeal of the assessee by saying that the tribunal has no justification to entertain the appeal. According to the tribunal, this was not an appealable order before the tribunal, and at the same time the tribunal said that the officer who has passed this order is equivalent to the rank of Commissioner of Income Tax Appeal, so that is also not an effectuous remedy. So the assessee was not having any option other than filing the writ petition in the court. When this matter was heard by the Honorable Kerala High Court, the court was of the view that if the officer was under the impression that this return has been filed earlier by his predecessor, then it was his at least duty to verify from the records whether that return has actually been filed, meaning thereby that the submission given by the assessee that just because he was under the impression that this return has been filed, that will not come into the definition of reasonable cause, which is there in section 273B, although there is no definition given in section 273B of reasonable cause, but the viewpoint of the court was that failure on the part of the assessee does not come into the definition of the reasonable cause as per section 273B. So the court declined to entertain the appeal of the assessee, the writ petition of the assessee, and the court also said that already in the present case the penalty, which was rupees 500 per day, has been levied only at the rate of rupees 100 per day. So the appeal of the assessee, so the writ petition of the assessee was dismissed. Friends, this case is very important because section 285BA is not known to many assessees and even the professionals also. It is not like that the annual information return is to be filed only by the banks or the non-banking finance companies or the registrar, but it has to be filed by the other assessees also, whose transactions come into the ambit of the transactions which are given in section 285BA. For example, if a private limited company issues shares capital to various shareholders, then in that case also those financial transaction has to be reported in the annual information return. So one have to check and one has to at least go through that section so that we can avoid these type of penalties. At the end of this video, once again I am repeating the name of the case. The name of the case is Sub Registrar versus Director of Income Tax Intelligence and another, and this case is reported in 483 ITR page number 21, and the date of the judgment is 14th July 2023. Thank you, friends.